It is 12 o'clock and we thank you all for joining us today for this webinar. My name is Dustin Saldaryaga and I am an associate at Scott Legal PC. We're going to spend some time today talking about the National Interest Waiver, or NIW green card. This is an underutilized green card category and one that we've started to see being used more and more, in particular by those who are entrepreneurs and coming to the US to support their entrepreneurial venture. A few things before we get started. Our firm is a full-service immigration firm, and we represent clients who are pursuing various types of visas, including those in the National Interest Waiver, or NIW category. This webinar is part of a series that will be continuing by doing at least 2 webinars a month on different immigration topics. We actually already have a number of webinars scheduled, and we will continue to regularly add more. At the end of this webinar, we will be sending you a few things. First, we'll send the PowerPoint from this presentation. We will also be sending a link to the recording of this webinar, as well as a comprehensive guide on the EB-2 NIW visa, which we'll be talking about today. And finally, we'll be sending you a link where you can sign up for additional upcoming webinars. A few housekeeping items before we get started. We do plan to reserve a few minutes at the end of the webinar for questions, but we will also be responding to questions as they come up throughout the presentation. So if you do have a question, please don't hesitate to send it to me. You can do so using either the question and answer box or the chat box through Zoom. Again, my name is Dustin Saldaryaga, and I will be the moderator for this webinar. We are very fortunate to have Ian Scott here to speak with us today about the EB-2 NIW visa. Ian is the founder of Scott Legal, and he has a vast amount of experience processing investor visas, including the EB-2 NIW visa we'll be speaking about today. So without further delay, I will turn it over to Ian to begin the presentation.
Great, thank you very much, Dustin. Perfect. So today, as Dustin mentioned, we're going to go over the National Interest Waiver. And as Dustin mentioned, it's really a category that has been underutilized. And the primary reason for that is that because in the past, the category was a very, very difficult category to get approved. But a few years ago, there was a case that was decided that completely changed the NIW standard, and it made it available to more than just people who, for example, created a life-saving vaccine or created a technology that was going to revolutionize the world. But it made it just much more accessible to individuals. And in particular, it made it much more accessible to entrepreneurs. So let's just go through the requirements. So the very first thing that you think of when you're thinking of or have to think of when you're thinking of a national interest waiver is that it falls under the EB-2 category of green cards. So the way that the employment-based green cards are handled is that they're are green cards through EB-1 through EB-5, and this one falls under the EB-2 category. Now, the EB-2 category covers national interest waiver, but it also covers the situation where a company wants to sponsor someone for a green card, and both of them have to meet the EB-2 threshold requirement, which is that the person has to have either an advanced degree or demonstrate that they have exceptional ability. Now, the advanced degree is quite objective for the most part, and what it means is that you have a master's degree or higher, or it means that you have a bachelor's degree plus 5 years of progressive work experience. So that's that's that. In order, and you always have to think about it even before you think about getting in and a national interest waiver. This is something that you have to make sure that you meet. So, for example, if you just had a high school degree, then obviously this particular threshold requirement you wouldn't meet. We'd have to move to the next one we're going to talk about. But if you only had a high school degree, you wouldn't meet this first one. But luckily there is an or. So the or says that if you don't have an advanced degree or you don't have a bachelor's degree plus 5 years experience, then you can meet the threshold requirement by showing the government that you have exceptional ability in the sciences, arts, or business. And then you have to, you can look at the, there are a number of, criteria. There's seven criteria, and you have to meet 3 of them. So for example, you may have a diploma certificate, or there's a work experience. So it's more work experience. It's 10 years of work experience. But you can, you can see all of the different criteria that are listed here there. And if you meet 3 of those, then you can meet the exceptional ability threshold requirement. Now, of course, this is much easier when you're qualifying under the advanced degree or the 5 years plus work experience, because the exceptional ability moves it from a fairly objective. If you have a master's degree, then it's completely objective. Moves it to somewhat subjective determination. So most of the NIWs that we do, the applicants meet the standard by qualifying under the advanced degree or the bachelor's degree plus 5 years of work experience. Now, one thing to note with this, it may come up a little later in the presentation, but I think I'll just note, make or describe it here. The degree has to be it has to be related to what your business is. So, let's say you have a degree in philosophy and you wanted to do a tech startup, then that will, even if it was a master's degree, then arguably you wouldn't meet this threshold requirement. So, sometimes we can really push the envelope and, take a degree. Like, so let's say, for example, you had a marketing, a degree in a master's in marketing, and you had a tech startup. We may be able to argue that marketing is a part and parcel to growing any business, and as a result of that, it's related enough so that we meet that particular requirement. But when you do look at the advanced degree or even the bachelor's degree plus the 5 years of work experience, there should be some relationship to what the actual endeavor is. So then once you meet that threshold requirement, then you can get into really, kind of what that case that I was talking about. The name of the case is Danisar, but the case really set the new standard and said that there are 3 criteria that have to be met in order to get a national interest waiver. So the first, and we're going to speak about these in more detail, so I'm just going to run through them now. But the first is that you have to prove that the proposed endeavor has substantial merit and national importance. The second is that you have to show that you're well positioned to advance the proposed endeavor. And the third is that you have to show on balance that it would be beneficial to the US to waive the labor certification process. Because remember, I mentioned at the beginning that the EB-2 covers 2 different types of green cards. One is a national interest waiver, but the other is when a company just wants to sponsor you for a green card. And when a company wants to sponsor you for a green card, the process that you go through is a labor certification process where you have to show the US government that you are unable to hire US workers. And so what this third requirement is really saying, it's saying that they want you to prove that it's on balance that they should actually waive that labor certification process. Perfect. So let's get into more detail on the with respect to the individual requirements. So with the first requirement, and this is one of the big problems with the old standard. Now, the first requirement, really, when you talk about substantial merit and national importance, in the past, when they had similar wording, but this case Danisar describes it in a lot more detail. In the past, what that meant was that the proposed endeavor had to have a national scope in that it had to affect or impact all aspects of the United States. So you couldn't get a national interest waiver approved in the past if you started a business in New York and really the business only affected or impacted residents of New York, right? So that would that wouldn't have qualified in the past. But the Danisar case made it very clear that a large geographical scope is not necessary for this, and that you could have, for example, something like employing workers in an economically depressed area. That could be sufficient to meet the substantial merit and national importance standard of Danisar. So it was a very, very big change, and it's one of the reasons that this particular category has been opened up so much. Now, the other thing to talk about is when we look at the third prong, where we say that you have to prove that the individual on balance, you have to prove that on balance, the government should waive the labor condition or labor certification process. Now, the other thing to think about here is, and we do a lot of national interest waivers for entrepreneurs, but the other thing to think about here is that entrepreneurs are not eligible to participate in the labor certification process. So, for example, when you own your own company, you can't sponsor yourself for a green card, or you can't sponsor your family for a green card. So, the argument that we often make here, and it's a successful when we make it successfully, is that that third prong really doesn't apply to entrepreneurs because it's impractical or impossible for them to obtain a green card through that process. And again, that's a successful argument. And in other cases where the person is not an entrepreneur, then what we argue is we use some of the same arguments from prong one, which show that, well, this the person's background or the economic impact or the impact of this particular endeavor is so worthwhile that it makes sense to waive the labor certification. So. Now, the other kind of thing to keep in mind, in particular related to entrepreneurs, is that before the Danisar case, we wouldn't have even have thought to use the national interest waiver for an entrepreneur. But the Danisar case does specifically mention entrepreneurs in the wording. So it's something, again, that has been very helpful with respect to opening up the opening up the ability to use this particular category. Perfect. So I think that one of the things that that often happens with a national interest waiver is that the individuals in the U.S. and they might be here on an E-2 visa, or they may be here on some other type of visa, but it would be a non-immigrant visa, and they're here, and then they decide that they want to apply for the national interest waiver, and there are definitely some timing considerations because the national interest waiver, unfortunately, is not eligible for premium processing. So when you submit the application, it could take 4 months, 5 months, a year and a half, 2 years, and all of those timeframes are timeframes that we've seen national interest waiver petitions process. So there is a fair amount of unpredictability with respect to when the petition would be processed. So if you have underlying status, you have to maintain it. So you have to be careful. So if you're on a TN visa, for example, and you only have 1 year left in your TN visa, and then you decide that you want to apply for a national interest waiver, you'd really have to get the green card before you had to renew your TN visa, because when the government knows that you plan on applying for a green card, they may not renew a non-immigrant visa. So it's just something you have to keep in mind. Filing the I-140 itself might not be a problem, but certainly if you file the I-485 with it, because when you file an I-140, as long as you are from certain countries, I think India and China are two countries where this would not be possible, but for all other countries, if you filed an I-140, you can also file if you're in the United States, you could also file an I-485 at the same time. And when you file the I-485, that definitely signals to the government that you are you have immigrant intent, or you've exercised it, you're actually applying for a green card in the U.S. So if you had to renew, if you didn't have underlying status and you had to renew your underlying status during that period, it would be very difficult. And if the I-485 it wouldn't be was filed, it wouldn't be possible. In terms of, with that adjusting status, with that comes a question of which is better to do, adjust status or do consular processing. And it really depends on your facts and circumstances. We had a client recently that we're doing a national interest waiver for, and he was in the United States, and he didn't realize that if we filed the I-485 petition in the United States, that there would be a period of time, 5 to 7 months, when he would not be able to travel. And that was not possible for him. It was, he had to be able to travel. He was on an E-2 visa and he had to be able to travel. So what we opted to do was file the national interest waiver, the green card piece of it. We're going to do consular processing. So we'd only file the I-140 here. And then once the I-140 is approved, then he would go to the consulate. And with that, he still may have some risk with respect to traveling, but it would be relatively small amount of risk that he would have with respect to entering the country and leaving. Now, in terms of when you're setting up a national interest waiver petition, and the question comes up of what should you include in the petition, and and what do we include in the petition? So, when we talked earlier about the threshold requirement, either an advanced degree or a bachelor's degree with 5 years experience. If you have an advanced degree, then obviously, if you have a master's degree, then obviously you would include information related to the particular degree, depending on how evident the link is between the degree and what you're doing, we may include transcripts as well. Certainly, if you're qualifying under bachelor's plus 5 years work experience, then you do need letters supporting the work experience, and they are fairly detailed letters. They're not just your resume and outlining, because the key is that the work experience is progressive, so your experience is building over time. So it would be formal letters from old employers that we would include in that case. In terms of meeting the 3 of the 7 criteria, you would include whatever evidence was relevant to show that you met them. So, for example, if you were looking at 10 years work experience, then you would include letters of employment that show that. If you were including the bachelor's degree, you would show that. If you were including memberships in particular organizations, you would show that. If it was high salary, you would show that. So whatever evidence you have to support that, you would include that in the petition. And usually that would go at the beginning to show that you've kind of met the threshold requirement. Now we move to the national interest waiver piece, and as I talk about this, we'll talk about it in relation to each of the 3 different prongs. So the first prong, we said, is that the proposed endeavor is of national importance. So with that, there's some work that we can do and the client can do in conjunction. For example, there may be newspaper articles on this particular endeavor. There might be academic papers on this particular endeavor that specifically mention how important it is to the nation. There's one famous case that has to do with, I think we talk about it later in the slides, but it had to do with an individual who obtained a national interest waiver because he had started consulting services to help vets, and he was a vet himself, to help vets as they came back to reestablish themselves and integrate back into society. And there's a lot of academic research and newspaper articles and research papers that support that. And he would have also included a number of different expert opinion letters to support that. So any objective evidence that supports that this particular endeavor is going to be important to the nation is going to be relevant. Now, the other thing that is included, so for example, if we have a national interest waiver that is for entrepreneurs, then we're going to include a business plan, because the business plan is going to show that the business that the person has started is one that's been started to create U.S. jobs. And there's an argument, when you have a national interest waiver for entrepreneurs, that alone is great for the nation. So sometimes when we do a national interest waiver and we talk about the endeavor being having substantial merit and national importance, if it is an entrepreneur, we try to do both. We try to include both the fact that the person is an entrepreneur, but then also, we may include other aspects of what it is, the benefit to the nation of what it is that they're doing. So let's say, for example, someone started a company that made a special type of face mask for coronavirus or something like that, and they were entrepreneur. We would focus on the fact that the face masks are good for the nation, but we would also focus on the fact that they're entrepreneurs and they're going to create U.S. jobs. So to support that would be a business plan. But also to support entrepreneurial endeavors for national interest waiver, we may get letters from economists, specialized letters from economists that talk about the impact. And then sometimes, for example, if the individual, let's say the individual is, the business is focused on a particular group that has not had been represented or has not had the advantages or support in the future, then that can be of assistance as well, because the government has always said that diversity is something that is important and is in the national interest, and sometimes you can use those arguments as well. So it's really, when you look at a case, you're looking at whatever is at your disposal to meet these 3 prongs. And that's why this particular type of petition, it's a very subjective petition. But if you stick to the basics and just say, I have to meet these 3 pieces of evidence, or 3 prongs, it's actually, I actually find them quite simple, in the sense of because they're overwhelming petitions in the sense that there's a lot of documentation associated with them. But at the end of the day, you're trying to prove to someone who is behind a counter, right, or behind a desk, that you have met these 3 criteria. And the criteria, they're not set in the statutes. They're set in this one case that relates to Danisar. And they're subject to interpretation, but it may be that in your particular petition you don't need one expert opinion letter. It's not relevant because it might be that it's so obvious that this is in the national interest, and you can support it with newspaper articles or academic papers. So these aren't cookie cutter petitions where where you have to include particular pieces of information. They're petitions where you have to sit back and think about what's the best information to include to be able to support what it is that I'm trying to support. The second prong has to do, and there's a bullet point on expert letters, and often these petitions do include expert opinion letters, but it's not always, and they don't always have to. The second prong that we talked about was that the person has to be well positioned to advance the endeavor. So the evidence that we would include there, a number of different pieces. So one, if the person, if their educational background or their work experience puts them in a place where they can do this, then advance the endeavor, then we would certainly include information related to that. But we'd also include information related to for example, let's say someone else is invested in the business, or let's say that the business has lots of contracts already, things that show that the business is going to succeed, because all of those really get at whether or not the person is well positioned to advance the endeavor. So any relevant information, and we also draw from some of the EB-1 criteria, that the extraordinary ability criteria, and we may pull things that show the person's significant contribution in the industry, like awards, patents, presentations, things like that. And we'll also, we'll also use some of those extraordinary ability aspects in the prong 3, because if we're trying to show why should we waive the labor certification, another good argument. And again, these arguments, they're not set in stone. They're arguments where you sit back and you think, how is it? What, like if the criteria is why should the government waive the labor certification? In some petition, in one type of petition, it might be something specific that you want to do to try and prove that. But the best thing to do is to sit back and think about what if I was behind a desk, what would it take to convince me with respect to why it is I should waive the labor certification? And it could be that you were able to form arguments that, well, this is an extraordinary, I certainly think that if someone is extraordinary, that's a good reason to waive the labor certification, right? If you're showing them that that this person has, exceptional education, this person has won a lot of awards, then, that's the exact reason that they get another visa without a labor certification, the EB-1, that's why they get that visa. So obviously the government already feels that way, that people who have some of these characteristics, from the EB-1, that they should waive the labor certification because the EB-1 doesn't have a labor certification, right? So you have to be always thinking about these, like when you're putting this particular type of petition together. It's reading the case, and it is lawyer's work, like in the sense of the case is a case written by a judge, and it is it is interpretation. But I think that often what we do is we'll work with clients to talk to them about the criteria and then extract from them what it is that they, things that may be able to assist them with respect to meeting the three criteria. So I talked about this a little bit and before, but this is another very famous case, and it was a famous case because it was a case where the service initially denied the case, and the person sued the government, and they appealed it because it was a BIA decision, and the Board of Immigration Appeals, and the Board of Immigration Appeals came back and they approved it, and they said, why. So this particular person was it was a small consulting firm. This was not a company that was going to make $1 million, or it was a company that was set up to help U.S. veterans, right? And so in terms of the substantial merit, the person submitted expert opinion letters. There were news, media articles, research reports, research reports, that explained. And I think, some of this stuff is obvious, right? Like it's you're not, when you, and that's great that it's obvious, because in terms of, it's not great that it's obvious that that's the way that it is, but great that it's obvious that it takes less to convince an examiner if it is obvious that, that people, when they come back from service, have difficulties, right? Adjusting into society after what they've seen. So that was how they met the first criteria. The second was that the person was able to, I believe the person was a veteran themselves, But that, that in itself wouldn't be enough. But they were able to get a number of different letters from government officials saying that they would support the program and that they would send people there, and things like that. And there were emails, letters from prospective clients, like, other vets, that confirming their interest in working for the company. The person had to show that they had sufficient startup capital to fund the company and execute the business plan. But keep in mind, for a business like that, the startup capital probably wouldn't have to be much, right? Like, so it's a, but you're just trying to show the government that this is going to work. Sometimes we do the same things. We're getting at the same things with an E2 visa, where we're showing the government that, we're trying to get at the idea that this particular business is viable, and we have to think of what is going to be useful to include to show that this particular business is viable. And I think that so thinking outside the box, or thinking very specifically about the case that you're working on, is what's really important with respect to getting these petitions approved. Because I think that sometimes people will take a very cookie cutter approach to this and say to clients, oh, well, you need 6 expert opinion letters, or you need, X, or you need Y. And I think that that's the wrong approach for these cases. I think that they have to be looked at individually. And then after you understand what's going on, then you look at them and say, then you sit back and say, well, what is the evidence that I think is going to best prove this in this particular case? And then the third prong, as I said before, this particular person was an entrepreneur. So we argued that the entrepreneurs aren't eligible for the labor condition application or labor certification process. And then it's again some of the same things that are in prong 1 and 2, like, the fact that he, again, the value of these particular services. So there's definitely overlap in prong 3 and prong 1 in particular. And it's, his track record of success. Because, well, to be quite honest with you, there's overlap in all of them. Because why should you waive the requirements of the job offer and labor certification? Get at, why is it important to the nation, and how amazing is this person, right? It's getting at, they're both getting at similar things. So a lot of the arguments for the third prong, we're reiterating them a lot of the arguments in the third prong, we're reiterating the arguments from the first and second prong.
Great, Ian, thank you. So that leads us to our question and answer period. We do not currently have any questions that have been presented through the chat box or Q&A box, but I want to give participants a few moments. If you want to chime in with any questions, now is your opportunity. All right.
Excellent.
I'm not seeing anything roll in. I do want to reiterate that we will, after this presentation, be sharing the PowerPoint, as well as a link to our future presentations. Ian, thank you so much for taking the time to speak with us and share all of this information. If anyone participating wants to watch this video again, we do post these videos on our YouTube channel. So visit there to see not only this video and other videos on the EB-2 NIW visa, but also the range of other visas that we assist our clients with. Thank you all for taking the time. Ian, again, thank you so much, and have a wonderful day.